We've got to talk about a brand new case that the United States Supreme Court has just agreed to hear, a case that builds on an earlier unanimous 9-0 ruling protecting our rights against warrantless entry, searches, and the seizure of firearms inside our own homes. This is one of those legal battles that could have huge consequences for every gun owner in the country, so let's break down what's at stake. As I mentioned at the top of this discussion, the Supreme Court has decided to take up a fresh challenge that centers on when law enforcement, and by extension, the government, can step inside your home without a judge's approval. This isn't just theory. It's about applying a prior unanimous Supreme Court decision that dealt specifically with police entering a residence, searching it, and seizing firearms without a warrant. The case on the docket is Case versus Montana, and it's a big deal for anyone who values the Second Amendment. At its core, this challenge is about stopping the use of legal loopholes that would allow officers not only to come into your home without a warrant, but also to walk out with your guns and potentially a whole lot of your other property as well. It's essentially an attempt to expand the precedent set by the 9-0 ruling in Caniglia versus Strom. The background here is pretty wild. This whole lawsuit started after Trevor Case's ex-girlfriend called the police claiming he had threatened to harm himself and that he might be armed. The officers involved already knew who Case was. There was a history of mental health concerns and previous run-ins with the law. When 4 officers rolled up to his house, they peered through the windows into each room but didn't spot him. One officer, however, noticed an empty handgun holster and a notepad inside. Concerned he might be in distress, they knocked on the door and swept flashlights through the windows, but Case never came to the door. After spending roughly 40 minutes outside the property, the officers decided to make entry through the unlocked front door. Several of them openly voiced concerns about going in, citing their previous run-ins with Trevor Case and the threats reported by his ex-girlfriend. They worried that crossing that threshold could quickly turn into a gunfight. At one point, they even tossed around the idea of calling his father to talk him down or trying to reach Case directly on his cell phone. In the end, they skipped those options, grabbed their patrol rifles and ballistic shields, and went in. Once inside, 2 officers swept the basement while the other 2 headed upstairs. As one officer stepped into an upstairs bedroom, a curtain suddenly snapped back. He caught sight of Case's face and a dark object in his hand. The officer reacted instantly, firing and hitting Case first in the arm and then in the stomach. The team rendered medical aid, and during the search, they located a handgun stuffed inside a laundry hamper near where Case had been found. That incident led to criminal charges against him, but Case's defense centered on the claim that the warrantless entry violated his Fourth Amendment protections and that the firearm and all related evidence should be thrown out. The lower courts didn't buy it, and the case eventually landed at the Montana Supreme Court, which in a tight 4-3 decision ruled against him. From there, the fight moved to the United States Supreme Court, which agreed to hear the appeal. The core question before the justices is this: can police enter a home without a search warrant when they have less than probable cause to believe an emergency is unfolding, or must the emergency aid exception still meet the probable cause standard? In his petition, Case points out that while the court has recognized narrow carve-outs for true emergencies, it has historically drawn those lines jealously and carefully. He argues the same standard should apply here, requiring a solid probable cause finding before officers can legally cross your threshold without a warrant. Case also leans heavily on the precedent set by Caniglia versus Strom, where the Supreme Court flat out rejected the idea of a broad, stand-alone community caretaking exception. The Montana Supreme Court, however, upheld the entry into his home under a watered-down community caretaking test that only called for reasonable suspicion of an emergency. According to Case and the dissenting Montana justices, that ruling flies in the face of Caniglia, lowers the legal bar, and risks expanding police authority beyond what the Constitution allows. For context, here's the backstory on the Caniglia decision. In that case, a husband and wife got into a heated argument. The husband placed a handgun on the table and told his wife she should put him out of his misery. She left for the night and stayed at a hotel. The next morning, unable to reach him, she called the police. When officers arrived, they ended up sending him to the hospital for a psychological check. Before leaving, Caniglia told the officers he did not consent to them taking his firearms, and they agreed. But after the ambulance took him away, officers told his wife falsely that he had given permission to collect his guns. She then let them into the house, and they seized the firearms. That case reached the Supreme Court in 2021, and the justices delivered a rare 9-0 unanimous opinion siding with Caniglia. They struck down the community caretaking reasoning used to justify the entry and firearm seizure, making it clear that such a justification doesn't stand on its own apart from recognized exigent circumstances that require probable cause. Since that ruling, the Supreme Court hasn't taken up another case directly dealing with when law enforcement can step into your home without a warrant. Now, with the case challenge, that Caniglia decision is being put back under the microscope and possibly on the path to expansion. Recently, a wave of amicus briefs landed in support of Trevor's case. One came from the Long Institute, an organization that champions the laws of nature and of nature's God as recognized in the Declaration of Independence. In their filing, they argue that the founders understood government was neither compassionate nor a benevolent caretaker. It was, at its core, an institution backed by force. Because of that reality, they worked to shield families and property from state intrusion, ratifying protections like the Second Amendment to ensure that citizens could defend their homes and their freedom. According to the Long Institute, the Montana Supreme Court's ruling cuts against that intent and should be overturned. More groups are now lining up to back Case's position, and that matters not just for him, but for every American. This case gives the Supreme Court a chance to put hard limits on warrantless entries and to reinforce, or even expand, the 9-0 Caniglia ruling. The decision could directly affect how much protection we actually have from the government forcing its way into our homes under the banner of exceptions to the Fourth Amendment. This is shaping up to be one of the more controversial and closely watched cases of the term, and we'll be tracking it every step of the way. When there's an update, you'll hear it here first. If you found this breakdown useful and want to help keep this channel going, the easiest way is to hit that subscribe button. You can also visit my website, armedscholar.com, where we've got a free legal guide you can sign up for. Thanks, as always, for your support, and remember, this nation was built by armed scholars, and it'll be preserved the same way.